Most retirees believe the home is the one thing Medicaid cannot touch. They're right, until the day they die. Here's what nobody explains. The exemption that kept your home safe while you were alive ends the moment you're gone. And in every single state in the country, there is a federal program designed to recover that money from your estate. The house you paid off, the house you lived in for 30 years, the house you plan to leave to your kids. There are two legal tools that block it. One costs around $200. The other costs nothing but a conversation with your family that most people never have. This video covers both, plus the tax shield that can pass up to $500,000 of home value to your heirs completely free of federal tax, and why most retirees lose it without ever knowing it existed. Let's get into it. Consider Barbara, 76 years old, retired postal worker from Dayton, Ohio. A folder of Medicaid approval letters sat on her kitchen table for 4 years while she was in a nursing facility. Her home, a modest house worth about $280,000, sat empty the whole time. Her family knew the home was exempt. Her caseworker confirmed it. Nobody counted it as an asset when she applied for benefits, so her daughter assumed it was protected. Barbara passed away in March. By July, there was a letter from the state, a formal recovery claim for $190,000, which was what Medicaid had spent on her care. And the home, the same home that had been listed as exempt on every form, was the primary asset the state intended to recover it from. Her daughter called it the letter that changed everything. Her brother Richard, 74, lived across the state. He had signed an enhanced life estate deed on his own home 4 years earlier, a single page filed at the county courthouse. When he passed 6 months after Barbara, the house transferred directly to his son. No letter from the state. Same federal program, different document. What the two outcomes actually changed was this family's understanding of what the word exempt means in Medicaid law. Here is the distinction most families miss. Exempt and protected are not the same word. Exempt means the government does not count the home against you when you apply for Medicaid. You can own a house worth $300,000 and still qualify for long-term care benefits. The home does not disqualify you. Protected means the state cannot come back for it after you die. Medicaid does not promise that. What federal law requires is a program called the Medicaid Estate Recovery Program. Every state in the country runs one. It applies to anyone who received long-term care benefits at age 55 or older. The mechanism is simple. While you are alive, Medicaid pays your nursing home bills. After you die, the state files a claim against your estate to recover what it spent, and the home is usually the only significant asset remaining. So Barbara's home was never at risk while she was alive. But the moment she died, that exemption expired, and the state did exactly what federal law required it to do. Now here is the part that changes the outcome. In most states, the Medicaid Estate Recovery Program can only reach assets that pass through probate. Probate is the court-supervised legal process that transfers your estate to your heirs after death. If the home goes through probate, the state can file a claim against it. If the home passes outside of probate, in most of those states, it is completely out of reach. That is why a $200 document can change everything. Let's talk about what probate actually costs, even when Medicaid is never part of your family's story. Because this expense is waiting for nearly everyone who does not plan around it. Arthur is 71, retired carpenter from Columbus, Ohio. His mother passed last year and left him the house through a standard will. No Medicaid involved. A certified letter from the probate court arrived in January. He spent 14 months waiting for a judge to transfer the title. Attorney fees, court filing costs, publication notices, executor compensation. When it was done, he had paid just over $21,000 out of a house worth $320,000. That is not unusual. Total probate costs typically run between 3% and 7% of the gross estate value. On a $320,000 home, that is up to $22,000 taken from the estate before a single heir receives anything. His neighbor across the street had done one thing differently. She filed a transfer on death deed the year before she died. One notarized form and a recording fee at the county courthouse. Total cost around $150. Her son received the deed 3 weeks after the funeral. No court, no 14-month wait, no bill. If this is making sense and you think more people should hear it, a like on this video helps it reach them. Back to what matters. The transfer on death deed is available in approximately 30 states. In Florida, Michigan, Texas, Vermont, and West Virginia, a similar instrument called the Enhanced Life Estate Deed, commonly known as the Lady Bird Deed, accomplishes the same result. Both tools pass the home outside of probate at death. Neither triggers the Medicaid 5-year look-back period. That is a critical difference from an irrevocable trust, which requires planning 5 years in advance. With a transfer on death deed or a Lady Bird deed, you can sign the document today. Now the tax side, and this is the layer most retirees never find on their own. Walter is 68, retired contractor from Michigan. His home is worth about $480,000. He paid $95,000 for it in 1989, and the original purchase appraisal is still folded inside his home insurance binder. That gap, $385,000 in appreciation, is sitting in that house right now. Most people assume selling a home with that kind of gain means a significant federal tax bill. Under Section 121 of the tax code, it does not have to. If you have lived in the home as your primary residence for at least 2 of the last 5 years, you can exclude up to $250,000 of capital gain if you are single, or up to $500,000 if you are married filing jointly. That gain is not deferred. It is permanently eliminated, and the exclusion covers the 3.8% net investment income tax on that amount as well. Walter could sell the home and owe 0 federal income tax on most of that $385,000 gain. His neighbor sold hers without knowing the rule. She had owned it for 28 years. She paid capital gains tax on a significant portion of the gain. The exclusion was there the entire time. But there is a second path, one that works even better if Walter keeps the home until he dies. Under current law, preserved by the tax legislation signed in July 2025, when someone inherits an asset, the cost basis resets to fair market value at the date of death. This is called the step-up in basis. Every dollar of appreciation Walter accumulated over 35 years disappears for his son's tax purposes the moment he inherits. His son's basis is $480,000. He sells for $480,000. He pays 0 capital gains, tax on $385,000 of growth. 2 legal paths. Which one serves Walter's family better depends on his health, his income in the year of the sale, and whether the home passes through probate or around it. That is the conversation the $200 document makes possible. Here is what all of this adds up to. The median home equity for homeowners 65 and older is $320,000. For many families, That is more than everything else in the estate combined. It is the asset they worked the longest to own, and the one they protected the least. No deed that bypasses probate. No plan for which tax path gives their heirs the better outcome. No awareness that the Medicaid exemption has an expiration date. A transfer on death deed in most states costs between $50 and $200. A Lady Bird deed in the states that allow it runs between $200 and $1,000. A conversation with an elder law attorney to confirm which applies in your state adds a few $100s more. The cost of not acting is measured in tens of thousands in probate fees, and the real possibility of a state recovery claim against whatever is left. There is no financial decision you will ever make that returns more per dollar than a $200 document you file while you still can. We come back to Barbara, to the letter her daughter received in July. That letter was not a surprise from the government. It was the consequence of a rule that has existed since 1993, and a single word, exempt, that nobody in her family ever stopped to question. The home was safe at 75. It was gone at 76. Not because the law changed, because nobody filed a $200 document. If the next thing you want to understand is how to identify the right tool for your state and how to decide between Section 121 and the step up for your family's specific situation, that is exactly what the next video covers.